The very concept of copyright, intellectual property, patent, trademark, and other such concepts are inherently unethical and dangerous for it and stop any progress of science, technology, and even social and moral factors. I'll relate this video before from a usually anarchist communist perspective. This time, Kevin Carson, one of the contributors of the only legal anarchist think tank in America and probably the world, the Center for a Stateless Society, has published his second edition of the case against intellectual property. For today's purposes, we're gonna read it from his perspective. He was an anarchist without adjectives, who was very heavily influenced by the mutualist approach to anarchism and the Boris Bookchin's later philosophy of anarchism of anarcho-communalism. So let's go straight to the analysis of why intellectual property of a libertarian critique, second edition from 2023. Preface for the second revised edition. In the 14 years since the original version of this paper was published, my political economic views has undergone ideological shift of the sort that might be expected of anyone who has remained intellectually engaged over a similar time period. If one were rewriting it from scratch, entire passages will no doubt be cut altogether, and most of the rest will be altered significantly in terms of emphasis and likely audience among other things. But this is a revision, not a rewrite. So minor stylistic changes aside, virtually all of the original text is still here and close to the original form. The major changes are all by way in addition and expansion, include topics either the original was deficient in addressing or has emerged or increased in importance. Under this first leaning is expand treatment of the structural role of intellectual property in global economy. In addition, I incorporate material from poetry and living in Against Intellectual Monopoly, which I had neglected to read while searching the original edition. As for the second category, this edition includes considerable new material on the role of intellectual property in enabling what is variously called virtual capitalism, strip shop capitalism, or incurring doctoral's apt term, aesthetification. Ethics of intellectual property. It's a contentious issue among libertarians. Among the individualist anarchists alone, Lysander Spooner took an absolute position in favor of patents and copyright, defending them as inviting in perpetuity, which Benjamin Tucker classified as one of his four monopolies. Although Tucker regularly relegated intellectual property to the last place among the four monopolies, he considered them entirely in terms of their effect on individual exchange, rather than their effect on industrial structure, or the structure and institutional relationship between businesses and the state. The proper emphasis was a general fading of talkers. After 1900, for example, when he finally began to recognize the trust as a problem, he assumed they had grown beyond the point at which eliminating the money, landlord, and other monopolies would do any good in reining them in. He ignored entirely the great extent of their dependencies as institutions on direct subsidies and other structured ties to the state. But in fairness to Tucker, at the time he wrote the passage quote above the corporate transformation of the economy was just getting well on the way, and the effect on individual property still fell primarily at the level of individual exchange. Ayn Rand record patent copyright as the legal implementation of the base of all property rights, a man's right to the product of his mind. Despite her defense of intellectual property as a property right rooted in natural law, interestingly, Rand did not pursue the principle consistently to the same logical conclusion as Spooner. Rather than treating it as a right in perpetuity comparable to tangible property right to devote the one's heirs and assign without limits, she dismissed perpetual duration as an obvious impossibility. Instead, she considered the possible law provision for copyright patent duration as the most rational solution. But the most absurd development in intellectual property absolutism was that of Andrew Galambos. As Stefan Kinsella's note, it's difficult to find published discussion of Galambos' ideas, apparently because of his own theories bizarrely restrict the ability of his supporter to disseminate them. Students attending his classes were required to sign non-disclosure agreement promising not to circulate his ideas outside the circle of paying customers. Galambos repeatedly dropped his nickel in a box of their hairs of Thomas Paine every time he used the word liberty, and juxtaposed his own first and middle names to avoid infringing on his father's intellectual property rights in the latter's name. If he paid royalties of the alphabet to the Tower Chamber of Commerce, there is no record of it. Among the Austrians, Ludwig von Mises, not an anarchist by the way, took a largely agnostic attitude towards the legitimacy of patents. As a purely utilitarian segment of their effect, he argued that they enable sellers to charge a monopoly price for goods that might not have been offered at all without the use of patents to recoup the cost development. Murray Rothbard, the godfather of quote-unquote anarcho-capitalism, on the other hand, was not shy in his denunciation of patents as a fundamental violation of free market principles. Rothman dismissed utilitarian argument for the patent, based on claims that are socially necessary to promote innovation. Why the contempt they deserve? This is incidentally the same sort of argument used for eminent domain when property is seized for the use of businesses that will be more valuable to the local economy. If Rodman rejected patents in principle, he considered copyright to be perfectly tenable and legitimate on the assumption that would be achieved through voluntary contract alone. But the sort of potential copyright regime Rodman envisioned would, in fact, be untenable in practice. First, as Quesada pointed out, contracts are only binding against the actual parties, so contractual copyright would be unenforceable against third parties who came into possession of copyright material. Second, there are serious practical questions about the legal enforcement of contractual copyright, so-called shrink wrap contracts, even against the accepting party settlement blogger Quas Bill or the Bell Tower. Rights of the serious problem the common law misundermined regard entails for contract enforcement in general. In particular, he mentioned that courts generally go to external evidence like standard market practices, course of industry, to ascertain subjective understanding or intent in determining whether a meeting of minds took place and an enforced contractual obligation therefore exists. But this line of reasoning, both the seller's and the buyer's reasonable expectation in regard to enforceability will play a large role in determining whether the buyer did indeed assume contractual copyright obligation. The mere act of purchases in the environment where verified compliance is costly and the risk of detection and sanctions are low. It is unlikely that either a buyer or a court after the fact will take any sound contract seriously. By way of analogy, some employers are demand as a condition of employment that employees not smoke even in their own homes. They refrain from borrowed discussion prejudicial to the employee's reputation, or they do not park on company premises with weapons concealed in the truck. In most cases, the employee is likely to sign an acknowledgement from and accept the job with their fingers crossed, with the mental reservation that it's none of my company's damn business. Is a job application asks questions the prospective employee considering inappropriate, noisy, or intrusive, i.e., political sympathy, social affiliations, and the like. They are likely to take the attitude that it's the prospective employee's problem to fire such things at their own effort and expense, or they want to know them badly enough. They are under no obligation to incriminate themselves. Kirsela has expressed skepticism in some regards regarding the enforceability of shrink wrap and click wrap contracts. Third, the enforcement of conceptual copyright, even if valid in law, will present enormous problems of verification of compliance. The enormous and draconian body of copyright legislation of the past 20 years should indicate the enforcement of copyright requirements and intrusive regulatory and surveillance states, and the copyright is virtually unenforceable without such mechanism. The new digital copyright regime has done away with the many traditional limitations of copyright from days when it affected mainly the printed medium, like the first sale and fair use doctrine. We can think the traditional exception to copyright, for example, for the public library and for the free access of photocopiers. Charles Charleston gives as the example the fair use exception, the common university practice making courses reserved available for photocopying, rather than expecting every student to buy a scholarly book at the academic publishing house secrets. I myself had numerous photocopies of books ordered through interlibrary loan, which would otherwise have cost me $70 or more, often for slim volumes of under 200 pages. In case of digital content, especially copyright, would be virtually unforeseeable without not only DRM, but the criminalization of technical means of circumventing it. Imagine buying a car with a contractual understanding that you wouldn't drive it to certain places that the leadership disapprove of. In the real world, such a contract would be a dead letter because of the high cost of verifying compliance. But if the contract were governed by the legal regime prevailing in the digital content industry, the car will be designed with building blocks against driving the car to forbidden places. Not only that, developing means to circumvent such blocks would be criminal acts. Doesn't sound very libertarian, does it? In The Right to Read, Richard Stallman depicted the inevitable object of such principles as depicted in the late 21st century society of the total copyright lockdown. There's a reason for such draconian control as described by Michael Buhlmann of the Foundation for Peer-to-Peer Alternatives. The corporate economy faces a growing crisis of realization. In monetizing and capturing profit from used value created in the immaterial realm is becoming increasingly impossible to capture value from the ownership of ideas, designs, and techniques. All the ephemeral and intellect Tom Peters write about as a component of commodity prices leads to a crisis of unsustainability for capitalism. In a later blog post from the P2P Foundation, Powers elaborate on the nature of cognitive capitalism as a response to the limits of accumulation of the finite physical realm, attempting a new form of accumulation based on ownership of the cognitive realm. This attempt is due to fail because of increasing untenability of copyright rights in the information realm. Various resources and input crises like peak oil, he wrote, are creating new limits to growth based on extensive expansion in the physical realm. He compares the imperative for capitalism to switch from extensive to intensive development to the parallel crisis of the chattel slave economy. However, he writes this is not feasible. The emergence of the pure model production based on the non-revolutionary nature and virtually non-existent marginal cost of reproduction of digital information and coupled with the increased enforceability of the intellectual property line means that capital is incapable of realizing returns on ownership in the content realm. Corporations rely on increasingly authoritarian governments with legislation to capture value from the property information. Johann Soderbergh compared the way photocopiers were monitored in the old USSR to protect the power elites in that country to the way the means of digital reproduction are monitored in this country to protect corporate power. The good news in all of this is that even the outward ratcheting of intellectual property law and the mandate electronic surveillance technology for enforcing it is still becoming unforeseeable in an age of BitTorrent, strong encryption, and proxy server hosted in the international anti-copyright havens. The DMCA is a dead letter for anyone who cares not to take even minimal trouble to circumnavigate. A good example is the so-called DECSS uprising, which followed from the attempt to suppress public discussion means of circulating DVD encryption. This incident and humiliating failure of so many corporate attempts, starting with the McLabel case in the UK, suppressed the free circulation of property information or supposedly libellous statements, should demonstrate this beyond the shadow of a doubt. Even such attempt inevitably result in a rapid transfer of files with prohibited information around the web, and the proliferation of mirror sites, order of magnitude faster than content owners can surprise in any particular violation. This will incorporate properties of information find themselves playing a whack-a-mole, and an offensive-defensive arms race between the authoritarian surveillance technologies requiring the enforced property content and circumventing technologies needed to trace such content freely. The defensive side will always be a step ahead. If the DMCA is unforeseeable even with the DRM, the criminalization of technical means of circumnavigation, and even with the taxpayer subsidy or the legal cost of enforcement, will become such an extensive copyright claim in a free market machine. In a free market machine, where enforcement of such claim is a private good provided at cost, the payment of contractual copyright enforcement will be dangerous, i.e. the cost will be borne by the beneficiary of enforcement. Intellectual property is a form of privilege, one example among many other broader category of artificial property rights. Like all forms of coercion, artificial property right creates a zero-sum situation which one party benefits if the other is spares. There's a symmetrical relationship which one party member and the other's loss. Whilst natural property rights benefit everyone, particularly individuals claim to the power of their own effort, artificial property rights enable the holder to collect tribute from the efforts of others. Natural property rights are a way of dealing with scarcity. Artificial property rights create scarcity. The distinction between natural and artificial property right is analogous to that of Albert J. Nock between labor-made and law-made property, where not for legal appropriation of the land, not arguing the engrossment of vacant and unimproved land to a favored class which did not appropriate it by its own labor, was unable to collect tribute from those who did, economic exploitation would be impossible. Historically, so long as wage employers had to compete with easy access to self-employment, there is a floor under the wages people are willing to work for and ceiling on the rate of profit. Defenders of intellectual property argue that innovators serve the scarcity gap as a reward for the net contribution to consumers' utility. If the consumer does not consider the innovation a benefit even at the dependent price, they are free not to buy it. Recent magazine Ronald Bailey, an enthusiastic supporter of the drug and biotech industry, is a good example of this latter argument. Studying a study that compared the overall economic value of consumers for increased life expectancy to the cost paid for drugs. He argued in the work his title that drug companies don't get enough money for life-saving benefit they gave us. But these are words for someone who's able to target the price of a good according to the consumer's benefit from it. A monopolist, the normal effect of the market competition is for productivity benefits are known military to translate technology directly into lower consumer prices. It's only through artificial property rights that privileged sellers can charge the consumer properly for their increasing utility and ability to pay, regardless of the cost of supplying the good. The term of that practice is price discrimination. In the words of Michel Baudrin and David Levine, competitors charge the same price to everyone, but Monevi is trying to extract a higher price to those who value the product more highly. Patents implement the normal process of market competition, which technological innovation translates directly into lower consumer costs. They enable the players to appropriate productivity gains for themselves rather than allow their benefit to be socialized through market competition. And apparently, I'm going to be very busy because I'm going to be interrupted. So, me being a lazy fuck, I'm gonna use a literal Google text to speech audio for the rest here out because it looks like I'm way too busy to do that right now. God damn it. So, here's the rest of the video without my voice.
Collect tribute for the service of not obstructing production. As John R. Cummins observed, the alleged service performed by the holder of artificial property rights and contributing some factor to production is defined entirely by his ability to obstruct access to it. As I wrote in Studies in Mutualist Political Economy, Marginalist Economics treated the existing structure of property rights over factors as a given and proceeded to show how the product would be distributed among these factors according to their marginal contribution. By this method, if slavery were still extant, a marginalist might with a straight face write of the marginal contribution of the slave to the product, and of the opportunity cost involved in committing the slave to one or another use. Such privileges, Maurice Daub argued, were analogous to a state grant of authority. Such privileges, Maurice Daub argued, were analogous to a state grant of authority to collect tolls. Such privileges, Maurice Daub argued, were analogous to a state grant of authority to collect tolls. Suppose that toll gates were a general institution, rooted in custom or ancient legal right. Could it reasonably be denied that there would be an important sense in which the income of the toll-owning class represented an appropriation of goods produced by others and not payment for an activity directed to the production or transformation of economic goods? Yet toll charges would be fixed in competition with alternative roadways, and hence would, presumably, represent prices fixed in an open market. Would not the opening and shedding of toll gates become an essential factor of production? According to most current definitions of a factor of production, with as much reason at any rate as many of the functions of the capitalist entrepreneur are so classed today, this factor, like others, could then be said to have a marginal productivity and its price be regarded as the measure and equivalent of the service it rendered. At any rate, where is a logical line to be drawn between toll gates and property rights over scarce resources in general? Thorstein Veblen made a similar distinction between property as capitalized serviceability versus capitalized disserviceability. The latter consisted of power advantages over rivals and the public which enabled owners to obstruct production. It is sometimes argued, in response to attacks on patents as monopolies, that all property is a monopoly. True, as far as it goes. But tangible property based on possession is a monopoly by the nature of the case. A parcel of land can only be occupied and used by one owner at a time because it is finite. By nature, two people cannot occupy the same physical space at the same time. Intellectual property, in contrast, is an artificial monopoly where scarcity would not otherwise exist. And unlike property in tangible goods and land, the defense of which is a necessary outgrowth of the attempt to maintain possession. Enforcement of property rights and ideas requires the invasion of someone else's space. Patents invade rather than defend property rights. Kinsella describes the way that intellectual property rights give the holder a right in other people's tangible property. An intellectual property right implies that a person who comes up with some useful or creative idea which can guide or direct an actor in the use of his own tangible property thereby instantly gains a right to control all of the tangible